All right, council's going to get us started off with House Bill 1339.
So this bill delays the effective date of Chapter 383 of 2020 from October 1, 2021 to July 1, 2022. The department is requesting this delay because the Child Support Administration is transitioning IT systems. Due to the pandemic, the transition will not be completed as originally anticipated for all of Maryland's 24 jurisdictions before the October 1, 2021 effective date. Failure to pass this bill will result in CSA expending approximately $100,000 to update both its current IT system and the new IT system.
Yes, I'll pass the House.
Move favorable. Pass.
It's been second. Everyone okay with that? All right. Excellent. All right, who's got House Bill 567?
That's Heather. Let me just write the 13, 30. You said House Bill 567?
Yeah.
Okay. So with House Bill 567, I'm also going to be referring to House Bill 313 because they are connected. The General Assembly cannot pass both of these bills. So in Prince George's County, under current law, a reserve study is a study of the reserves required for future major repairs and replacements of the common elements of a cooperative or condominium or the common areas of an HOA. So current law specifies the time when an initial and updated reserve studies are required to be conducted, and the governing body shall provide funds to fund the reserve in accordance with the most recent reserve study. So again, under the current law, these provisions are limited to Prince George's County. House Bill 313 would extend these provisions statewide. However, House Bill 567 would apply these provisions specifically to Montgomery County. So the reason why there are these two bills before us, even though you can't pass both of them, is because if the statewide bill does not pass, the request is from Montgomery County to still extend these provisions as a local bill.
Senator Jackson?
Say move favorable.
Or well, obviously the statewide one. Let's discuss. Yeah.
Yeah, the state. So
So
you said
on-
even if the statewide one did not pass, Montgomery County wants to be considered?
Correct. If the statewide one does not pass, then we'll talk about the countywide one because Montgomery County wants it.
Well,
But that doesn't. I mean, this is the first one we're talking about is a statewide bill.
Well, I would move favorable on that. We already enjoyed it in Prince George's County.
So it's 13.
House Bill 313.
313.
House Bill 313.
Yeah, absolutely. Move favorable.
I thought we were doing 564 and 567. Now we're on to 313. Did we pass the other ones?
So House Bill 313 is the statewide version, and House Bill 567 is if the statewide version does not pass, Montgomery County wants it to pass for their county. So that's why you have the two bill numbers going around at the same time.
Am I still on? Yeah, my concern in this thing is how much are these reserve studies going to cost? I hate to require condominiums, et cetera, to spend on cooperative housing. Cooperative housing corporations, cooperatives, the residents own it. It's not somebody else is involved, and the condominiums, the residents own their own condominiums. So this would require people who have bought condominiums to spend money. And do we have any indication of how much these reserve studies are going to cost? We have to do it every 5 years. They're going to have to spend some money. Are we talking about spending $100 or spending $100,000? How much do these things cost?
Why don't we punt on the statewide bill, let Montgomery County chew on it for a year and then come back? Why don't we punt on the statewide bill, enact the Montgomery County one as a test case, and if they're happy with it, they can deal with any issues, and then we come back and expand it.
That's that. I mean,
Let's just do the Montgomery County one, see how your pilot program works.
anyone else? I mean, we're going to roll with Montgomery County, but the statewide stuff is on you guys. So,
I mean, we've already gotten, Prince George's, we got a difference in start times here anyway, and the other counties are after October 2021. I'd rather let you guys work out the kinks if they're pretty much identical bills, come back next year and people can add counties in.
Someone, did someone mention holding the bill? Okay, I'll do that, and I'll try to get that information regarding the cost of that. I mean, we've been running it in Prince George's, and but I'll move favorable. If you could hold, Mr. Chair. And then, you know, in deference to my Montgomery County colleagues, move favorable.
motion for House Bill 567. Is everyone okay with that? All right, excellent. We'll hold the other one. All right, we'll now go on to House Bill 769.
This is me too. Oh. This bill clarifies that a committee of the Montgomery County Housing Opportunities Commission is a public body for purposes of the Open Meetings Act.
Bill, do we have a letter? We have a letter. Sandy's shaking her head yes.
It's House Bill 769. It just adds the commission to the Open Meetings Act.
Oh, yeah, I remember, this is an Alpar bill.
Yeah.
Housing Opportunities Commission is like quasi-public, quasi-private, and it just makes clear that they got open meeting.
They have to have their subject to Open Meetings Act.
Yeah. I think that's what it does.
Senator West, we do have a delegation letter. Is everyone okay? All right.
Montgomery County Day in JPR.
Yeah.
They've done this before. Isn't there, so you're making them subject to a public body for purposes of, we've seen a couple of bills out of Montgomery County like that, but not other counties. Is it for transparency purposes?
Yeah, and we've got these like half private, half public. Agencies are like, and so it's unclear where they live.
Okay,
And we're saying for public meetings, they live on the public side.
right. I mean, if Montgomery County is just more proactive on opening to the public, because we've seen a number of these on Montgomery, and I
Yep.
don't remember another county.
Well, you know, and we've got, with Prince George's County, we've got like Park and Planning. It's a bi-county agency. We've
Yeah.
got WSSC, which is like,
Yeah, you
Sort
have
of.
some weird stuff down there.
Yeah.
Yeah, okay. Thanks.
Okay. Let's go with House Bill 1248.
House Bill 1248 requires by March 1st, 2022, and each March 1st thereafter, each local law enforcement agency to report to the Governor's Office of Crime Prevention, Youth, and Victim Services information on each incident for the previous calendar year involving a police officer employed by the law enforcement agency that resulted in a monetary settlement or judgment against the law enforcement agency. The Governor's Office of Crime Prevention, Youth, and Victim Services must adopt procedures for the collection and analysis of the required information. By June 30th each year, compile and submit an annual report on the required information to the General Assembly, and annually post the report on its website.
Favorable.
This is House Bill 1248.
Yeah, he's like Leon Perel. Yeah. Executive Director of Men and Family Center, East Baltimore.
He's got the wrong bill number, obviously.
Yeah.
Or got put in the wrong place.
He was the only one that was unfavorable.
But he was talking about the wrong bill.
Yes. Senator Jackson.
Yes, thank you, Mr. Chairman. I think this is pretty much in line with what we've been doing with police reform. It adds another layer of transparency. I think jurisdictions have for a long time been able to we're not required to disclose this information. So I think it just falls right in line with what we're doing here. Just as a backdrop, the sponsor of this bill served on or as one of the chairs for the Prince George's County Police Reform for our county executive, and this is one of the recommendations that came out of that, but they needed to bring it here. So I think it's a good thing. It's about transparency, and as we're working toward police reform and regaining the trust of the public, I think the government, I think I've said this a million times, accountability starts at the top. Somebody sanctions good and bad behavior. And so if the more the public knows about what's going on, the better we can deal with this. So I'd move favorable on the bill.
Incident, is that defined in this bill or in the public safety article? We have to report on all incidents.
Doesn't appear that it's defined in the bill, so I think it would be up to the Governor's Office of Crime Prevention, Youth, and Victim Services. They're required to adopt those procedures for the collection and analysis of the information, so I think they would, in doing that, more than likely define what's required. How it meets,
my concern is
what's required to be
this is every
reported.
little every automobile accident. Anytime an officer breaks his foot and does a workers' comp settlement, there's just tons of crap here that's an incident. If you don't otherwise define it, that results in a monetary settlement or judgment against the law. I mean, there's just
Sure, and I just, my reading of it is that I don't think that those things would be excluded necessarily. Like that, if it involved a monetary settlement or judgment, it would be in.
Yeah, so every worker, I mean, there's tons of workers' comp claims and stuff because they slip and fall, twist their back getting out of their car. So all the workers' comp stuff will be going, and then it has to include their age.
Now, you would be able to sort of distinguish what it was based on the data, because the reporting would require a brief description of the circumstances surrounding the incident.
No, I got that. You can, just why? We're just dumping so many reporting requirements on police agencies around the state, and now we're going to be pulling in another report that's going to be rather large that has a whole bunch of useless stuff in it. I don't know why we would need to provide them with greater oversight about workers' comp claims than any other, or their automobile liability insurers, which is going to be probably 95% of everything you're going to get on this report is going to be all that kind of crap that nobody's really wants. I don't see a reason to get if the incident was something relating to the public or interactions with the public? I mean,
24 and 25, one of the prongs is the amount of the settlement or judgment awarded to the plaintiff. So, I mean, if you think about that, a workers' compensation case, the officer themselves, they're essentially the plaintiff. So I don't think that that's what's being contemplated in this legislation.
well, and I agree. That's what you're going to get, though. I'm just trying to make clear here that it ought to, we ought to be excluding things like automobile accidents and workers' comp claims. Otherwise, you get this massive report that's going to, and you're going to have to skim through it to try to find out if there's anything in here that's not workers' comp. I mean, it'll be 50 pages long instead of 1 page.
All right, we're going to move on to Senator West and then go to Senator Jackson. But counsel, can you, there's somewhat of like a narrative statement here with it says, since it is assumed that the bill applies to a limited number of cases each year, local finances are not likely not materially affected. If you could just dig in on that. Sure. Senator West.
I essentially want to read it. Not sure what that is. I wanted to largely agree with Senator Cassidy on this. It seems to me that it should be easy to exclude incidents which don't result in monetary amount in excess of, $5,000 or some. We're talking about minor things. Otherwise, not only does the local law enforcement office have to report it to the state, but then the state has to render an annual report on the information required under this section to the General Assembly. So we're going to get reports about every minor incident in which a policeman slips and falls and skins his knee and makes a workers' comp claim. It just seems to be overkill.
Well, I guess if you, well, I think a lot of what we've done this session is overkill, quite frankly. So let me just start off with that. But I'll leave it at that because we are being recorded. But what I will say is this: look, for forever, when these incidents occur, we have to report it to our finance department and to the county government. And when the settlements are, they are just not disclosed. And I think in an effort for transparency, they were asking for these. And could it be narrowed to, but how would you specify the incident? Is it law enforcement officer, has an accident, you have some, victims, they sue the county or the city or the state, and, do we, or is it police involved incidents to that effect? Or do we specify, if I get a workers' comp injury, that payoff is already in county records. I'm not sure where it goes or if it goes anywhere outside of the county. I think I still believe this is a good bill. I think I would have problems confining it to what we should list and what we should not list. The involvement with officers is so expansive. I think that we run the risk of missing it. This is generalized, and maybe we can look at it later. But I still move favorable on the bill.
Second, who's been favorable, who's in second? Senator Cassidy, go ahead, and then we'll roll, see what happens.
I propose an amendment that states that incident does not include workers' comp actions or automobile liability issues. And just explaining it, it would just knock out a whole bunch of crap and just simplify this report. The report will be better because nobody cares about these worker comp claims or these automobile liability claims, which is going to be so much what this report's going to produce. I mean, you can get it. If we wanted to audit them, you can get it, but the General Assembly doesn't care about that stuff any more than we care about workers' comp claims made by the people in the state highway or whatever.
All right, let's go to Senator. You got a motion for the favorable, and it's been seconded. Then there's been a motion for an amendment, and that was seconded. So we got to do one before the other. But Senator Jackson, go ahead. I'll give you the last word here. What are your thoughts?
So, Senator Cassidy, well, on the workers' comp stuff, I mean, look, if you're talking about automobile liability, I mean, you know how many accidents officers get in that you have plaintiffs? I mean, there's a lot of money that goes out of each jurisdiction there. And I think that goes back to something we talked about from day one. There's a training component there. There's an account. The little bit of money that I'm paying out, or the lot of money, the large amount of money I'm paying out of my pocket, I make up on overtime or part-time. So I think this is about the accountability of agencies, and if the agencies are paying out an excessive amount of money in any area, whether that's vehicle liabilities or some use of force complaints or anything else, I think, the public has a right to know that. As far as the, so I would resist that portion of the amendment, and I probably would resist the workers' comp piece as well. I mean, I think we can refine it going forward.
Yeah, okay, so I understood this report to be getting at, which the state would have an interest in, whether we're paying off people who are making complaints against the police because the officers' malfeasance towards the public, which we would have an interest in. But this state we don't have an interest in the, automobile accidents are paid for by the county. I don't know why I would have any interest in how many automobile accidents are being claimed in your county or any of us. That's your, and I don't, to turn the General Assembly into county councils or local auditors is totally non-productive here. We got to recognize some structure of government, and things like workers' comp claims. Again, these are all county level things, and why we are going to have a report come up. I mean, we might as well have them making reports up about manhole covers and stuff, because those are all, these are county level issues, use of force kind of complaints. So, thank you.
I believe we had a motion first to move the bill, did we not? If I were a taxpayer, I'd want to know about this information, where your money's going to, what you're paying for, these settlements and all these other things. Thank you.
But it's good.
If you roll it on a straight favorable, I mean, how do you take any amendments to something? I mean, I guess we can just sit here and roll things on favorable, unfavorable, but it seems to me
The motion was made first. That's why I meant to entertain it first. That's the only thing. We talked about.
I mean, it just seemed to me, just out of courtesy, we got to look at the amendment. The amendment's just saying that you don't want a bunch of auto accidents and workers' comp stuff on these reports, and they got to report it up. You want hundreds of workers' comp things in there and auto accidents. Seems to me he's trying to help fix the bill, right? You're trying to remove a bunch of frivolous stuff so they don't have to sit there and report it all. I mean,
I'm just rolling
just making the case on why we should take the amendment. You want the police out actually policing and doing stuff. You want them to be like bean counters, like writing up reports of workers' comps and sending them someplace else. Like, what the hell does worker comp have us? Like, we don't even deal with that issue in this committee. That's finance.
Senator Jackson, you want to entertain the motion?
Okay, this is what I'll say. How about we do this? So this bill came from a member who sat on our local police reform, and this was a matter that had to be brought here. Now, what I will say to you is, I will have a conversation with that individual, but right now, I want to roll the vote. And if that changes, I'll accept your friendly amendment on the floor.
Yeah, sure.
So, I apologize. I was focused on a bill that's coming up, but isn't the intent of the sponsor that this be for use of force incidents? Isn't that why we're sending this to the Office of Crime Prevention, Youth and Victim Services?
We're going to rename them automobile accidents and workers' comp.
I'm sorry. Well, I mean, I don't know. I was not as closely focused on your amendment as I should have been, but couldn't we just add police use of force incidents? Wouldn't that solve the issue? Isn't that what we're trying to do here? I mean, I guess I'll ask the gentleman from Prince George's County. Isn't that what our attempt here is? You just have to add the words use of force.
You cut out a little bit. Say it again.
So online, so look at the bill. On line 9, on page 2, couldn't you just have it read, and tell me if this is the intent of the sponsor and of you, for the previous calendar year, each use of force incident involving a police officer employed by the law enforcement agency that resulted in a monetary settlement or judgment against the law enforcement agency. Isn't that the intent of the bill?
Yes. Yes. Sorry. Got it.
Or a favorable motion to amend it to reflect that, or do you want to?
It's a friendly amendment. It's not.
I know.
It's a very friendly amendment. It's not.
Yeah. Yes.
I'm just honoring the procedure. So there was one amendment first, but you made the motion. So
I will retract my motion,
it's whatever you want to do. Yeah.
and I think I'll roll with the one that keeps it where it needs to be, except outside of trying to specify specifics. Yes.
Are you taking that? All right. So who's counsel on this? Jamie. Do you have this? Yep. Okay. Is everyone okay with that?
So what's the amendment of the judges?
Yes. So winnows it down. Yeah. You retracted your initial motion. Is there another motion now to roll the bill as amended?
As amended, I move in favor.
Seconded. What are you guys going to do? All right. So rolls, everyone's in favor? Okay. All right, House Bill 1117.
House Bill 1117 prohibits a pedestrian from catching or attempting to catch fish by any means on or under the Maryland Route 18 Kent Island drawbridge over the Kent Narrows in Queen Anne's County. It would take effect July 1, 2021.
What's this bill do? Second. You can't fish off a drawbridge? Hold on. What's this?
There are two bridges at the Kent Narrows. Which one is this we're talking about?
All right,
Team drawbridge. I'm not familiar with the area, Senator. I'm sorry.
I swear to God, we're only spending like a minute on this bill, but
Yeah, look, so, Mr. Chairman, I really need to know what the intent of this bill is. I want to follow my colleague, Senator Cassidy, on what this really intends. Does that mean, can me and my grandbabies pull up and fish on that bridge, or I have to have a?
all right, time is ticking on this bill. We are spending
delegation letter.
literally 45 more seconds on this bill. All right. All right, so is everyone okay?
You're the DNR guy.
We've got 15 more seconds on this bill.
So I do understand that this is a local bill and we have a local letter. But my question is, when they talk about underneath the the bridge, right? If you go underneath on either side, there are areas that are like parks where people go there and fish underneath. And I don't know. I guess by the way I read this, that would be prohibiting those people from access.
All right. Well, I guess this bill is in the drawer for the rest of the session. All right. We're going to go on to House Bill 941.
Which one? 941. 941.
House Bill 941 authorizes Baltimore City to decrease or raise to a previously established level the maximum speed limit on a highway under its jurisdiction without performing an engineering and traffic investigation. The bill also prohibits a local jurisdiction from implementing a new speed camera on any portion of a highway for which the limit has been decreased without performing an engineering and traffic investigation.
So we got a bill on the floor right now that allows Baltimore City to put that new speed camera on all those drivers from Baltimore County, and then this bill would allow them to, will this allow them to lower the speed limit on that road?
Only to a level that was previously the speed limit, and if they decreased it under that authority, they would not be able to put the speed cameras in.
It said with a study. It said you have to do a study, and then you can put the cameras on.
So normally you have to do a study to change the speed limit. What this bill would say that in Baltimore City, they can change it to a previously established speed limit without the study.
So what was the previous, was there a previous speed limit on 83, the one we just argued yesterday?
I am not aware of that.
Yeah, I know a study. I mean, you send one consultant out there for a day. Yep, it's good. Let's go ahead and lower this and put the cameras.
I'm going to pursue exactly the same line of inquiry. So yesterday, we allowed Baltimore City, where the bill's on the floor, to allow Baltimore City to implement speed cameras to trap my constituents and Senator Hettleman's constituents as they come down the highway. And this bill apparently allows them to reduce the speed on the highway to whatever, to an unrealistically low level, so more people will be trapped by the speed cameras.
I would say that is a bit of a mischaracterization and exaggeration to say, you know, it's a ridiculously low speed level. As the council clearly said, it happens either after a study or only to some speed that was previously authorized.
So
that's just inaccurate, Senator.
And just to clarify, the way the bill was amended in the House, it would prohibit any jurisdiction who lowers the speed limit without performing a study from putting a speed camera on that portion of the road that the speed limit had been reduced on. That would apply statewide.
Except Baltimore City.
No, they would also, the authorization is for Baltimore City to decrease or raise to a previously established level a speed limit without a study, and then there would be a statewide prohibition on anyone who decreases a limit without a study placing a speed camera on that portion of the
Fine,
road.
the Jones Falls Expressway was built in my lifetime, about the late 1950s, early 1960s. What were the previously established speed levels on the Jones Falls Expressway since its construction?
I would have to look into that, Senator.
Well, I'd like to know what the lowest level was, because, go ahead.
It was during, I think it's during Carter's presidency when they had the energy crisis. Remember, they lowered the speed limit everywhere nationally to 55 miles an hour. And then in the 90s, we repealed that. In fact, the state of Maryland, we went up to a maximum of 70. So I can tell you on any road in the state of Maryland, it was at least 55 previously as the max.
Thank you. I believe if you look at the city's testimony and the draft information about speed management and the like, we're not talking about I-83, we're actually talking about neighborhood streets, because they give a list of targeted speeds on a number of these streets, and none of these places are talking or looking at that. So that's it. I'd move favorably.
But Senator Council, go ahead.
So I'm just trying to understand what council said. What we've got in front of us, the House bill, are there amendments, or is this?
There were amendments made in the House. There are no amendments here in the Senate.
So the amendments in the House are what we have before us, right? I mean, I'm sorry, I'm not sure if I'm looking at the right thing. I have something that says House bill, and it's got some strikeouts on it. God damn it. Did we get something else from them?
No, I believe you're looking at the third reader of the House bill, Senator.
Okay, it says Baltimore City is stricken out, and it says motor vehicles, speed limits established and enforcement. That's the right one, right?
Correct, exactly.
Okay, and then it says that Baltimore City may decrease or raise to a previously established level the maximum speed limit on a highway under its jurisdiction without performing an engineering study. So normally jurisdictions have to perform an engineering study before they do that, I assume, under state law, right?
In most scenarios, yes.
But we're going to say that of all the jurisdictions, but then we're going to say Baltimore City doesn't have to perform engineering studies. Why eliminate that? engineering studies are normally done for purposes of traffic safety and to make sure that people aren't just arbitrarily jerking around speed limits. So why would we want to do this without a traffic engineering study?
I can't speak for the bill sponsor, but I would note that it's limited to the situation where you're raising or lowering it to somewhere where it previously was in the past.
No, I got it, but some of the streets were created in 1850, and the speed limit was probably as fast as your horse could trot. And so, I mean, I can't support a bill that's saying just eliminate in one jurisdiction something we apply in every other jurisdiction. That doesn't make any sense at all. This doesn't make any sense that you wouldn't at least perform a rudimentary traffic study. They're not like $1 million study. You have your own traffic engineers on staff. It doesn't make any sense.
Yes, thank you, Mr. Chair. I've got a question for council. I've been advised over here that Baltimore City streets are defined as highways in state law. Is that correct? What
Yes.
is a highway in state law?
I can bring up that definition. It is 101. So I believe it's Transportation Article 21-101. Or sorry, maybe 11-101, sorry. 21-11-101 or 21, sorry, Transportation Article 11-127. Highway means the entire width between the boundary lines of any way or thoroughfare of which any part is used for public vehicular travel, whether or not the way or thoroughfare has been dedicated to the public and accepted by any proper authority. So it essentially means any road.
So under that definition, a Baltimore City alley would be considered a highway?
I believe so, yes.
Wow, you learn something every day. All right, so it's not just the Jones Falls Expressway, but the Jones Falls Expressway would be included in the definition of the word highway.
Correct.
Okay, thank you.
No. Yes.
I'm sorry.
This bill moves the vote to the delegation. Do we have a Senate delegation letter?
Do you have a Senate delegation letter?
Yeah. All right, we'll get one. We'll get one.
I'll check.
I have not received one, no.
Or 74. Lord help us on this one. This should be pretty simple. All right.
That's a Ways and Means bill.
Is it 383? Sorry.
That was going to be awesome. Start doing
Winery. I was like, why do we have this? 383. Traffic. There we go. Delegate Carr. 383. Sorry. 383. Yeah, I wish we had 474. That'd be great.
Josh.
House Bill 383, by repealing an exclusion, subjects a motor vehicle rental company as the owner of a vehicle to enforcement of violations recorded by traffic control signal monitoring systems or red light cameras. Before mailing a citation, the relevant law enforcement agency must send a notice to the rental company stating that a citation will be mailed to the company unless within 45 days of receiving the notice, the rental company provides the law enforcement agency with a statement under oath of the name and last known address of the individual driving or renting the vehicle when the violation occurred, a statement under oath that the vehicle was stolen at the time of the violation, and a copy of the police report, or...
Josh, it's never mind. This one's dead. Okay. I don't know why it's on this on the list. Yeah. All right.
Did you mean it was
That would also be awesome if we moved it.
Yeah, this is awesome if we move that. All right.
313?
313.
That could have been it. We already discussed that one.
Okay.
That one was done.
All right. Now let's move on to the housing bill then. The 1312. All right, so Senator Heddleman, 1312.
So, House Bill 1312. There was an amendment that was passed out yesterday. If you still have a copy of that, I can tell you what the differences are in the bill. So the first change is on page 5 of the bill to alter the definition of tenant to specify that the tenant must be an individual under a claim of legal right to be in possession of the property. The reason for this is because because under the current definitions of the bill, this bill could comply or apply to failure to pay rent, holdover, breach of lease, and maybe even wrongful detainer. And wrongful detainer is like a squatter, and so the goal is to not let this apply to that. So it's only claim of legal right.
What's the new language that you chose to put in here?
So tenant means any individual occupying a land or property under a claim of legal right from a landlord. So I'd pull the language from House Bill 18 to model the definition. Yes.
Another one. They just did this.
So the next change is in line 15. Beginning on line 15, so in line 17, a tenant may raise a substantial loss of income as an affirmative defense in a failure to pay rent proceeding during a catastrophic health emergency. So currently the bill applies to evictions, which would be all types of evictions, and this proposed amendment would narrow it down specifically only to failure to pay rent causes of action. The next change that that would be made is on page 6 of the reprint. Subsection C, beginning on line 6 of page 6, that would be deleted in its entirety. The rationale is that the goal is to tie the failure or the substantial loss of income affirmative defense specifically to failure to pay rent causes of action. So that way, under this proposed change, a tenant who is being evicted for breach of lease could not counter the breach of lease claim with a affirmative defense of failure to pay rent. That would be the effect of deleting subsection C. There would be a clarifying change in line 17 on page 6 to delete the breach of lease citation, which would be to delete line 17, page 6, 8-402.1.
What are you deleting?
8-402.1?
Yeah, what are you deleting? You're just deleting the whole thing.
No, just that reference. So all subsection C is deleted. And then in D1, the corresponding change to make it clear that this is only applying to failure to pay rent.
Got it.
So depending if you're looking at the old copy of the amendment or the new copy, yesterday the proposal was in 8-1004 to tie this to substantial loss of income. So line 23 on page 6 would be reworded. During a catastrophic health emergency, comma, if a tenant has demonstrated a substantial loss of income, comma, a landlord may not increase the rent payment of the tenant or charge the tenant a fine or a fee for the non-payment, and then the remainder would remain the same. Then continuing on to 8-1005, we're now in subsection A. The proposed change here would be to tie subsection A to a catastrophic health emergency. So this section applies only if the state, local government, or federal government during a catastrophic health emergency has established a program to provide rental assistance in the jurisdiction where the leased premise is located. And those are that's it for the changes that I have.
Senator Hellman.
Question. So someone would not have as an affirmative defense under a tenant holding over the substantial loss of income argument?
So if the landlord is filing for holdover, you would go to 8-1005.
Right.
So first you'd go to C. So has the landlord received rental assistance to cure the tenant's arrears? And if they have, then they have to wait 120 days. If the landlord, and then there's subsection D, which is the general rule. So during a catastrophic health emergency and within 30 days after the expiration of termination of the catastrophic health emergency, the landlord may not file a claim in the district court to evict a tenant for holdover. So that applies whether or not the tenant has substantial loss of income or not. And then it provides unless, then 1 through 6 specifies the exception when a landlord may file for holdover.
Right, but I'm still a little confused. So nothing precludes, if the landlord still tries to non-renew the lease, they can use as they can still, it would be codified in here that they can still use as an affirmative defense that they have a substantial loss of income due to COVID.
You do it all unless you're in 1 through 6.
Right.
The tenant, so the general rule is a landlord cannot file for holdover.
Right. Okay.
So to give you a hypothetical, what would happen is the landlord wants to file for, so tenant cannot pay the rent.
Yep.
Because the tenant has substantial loss of income. The landlord wants to file for failure to pay rent. Well, if the landlord does that, then the tenant can raise substantial loss of income affirmative defense. And you go through that process.
Yep.
Or under what sounds like your hypo is the tenant has suffered a substantial loss of income. The landlord knows that there's this affirmative defense, so decides, I'm not going to file for failure to pay your rent because I know that they'll just raise the defense. Instead, I'm going to skirt around that issue and I'm going to just decide not to renew their lease. So I'm going to give them the notice and then I will just, if they try to stay, evict them for holdover. What this bill would do is says, sorry, you cannot file for holdover unless you fit one of these 6
categories.
Exceptions.
Okay. Helpful. Thank you.
All right, so I think the work we're working on this. So can we adopt those amendments that you just offered here and work off this from now? Is everyone okay with that? Okay, great. Are there further questions?
I just have one question.
Sure.
So with the amended changes, and I apologize, I was digging through my piles here trying to find the one we were working off yesterday. Did we tie the rent caps, that part, to catastrophic and loss of income? Yeah, 8-104, I believe, was the.
We did that yesterday.
Yeah, so page 6, line 23 would be reworded as follows. During a catastrophic health emergency, if a tenant has demonstrated a substantial loss of income, a landlord may not increase the rent payment of the tenant or charge the tenant a fine or fee for non-payment.
Okay.
Thank you, Mr. Chair. And referring to that same section, it was confirmed back in our work group that the landlord's way to get around this problem, which is would be entirely legal, is to sign when the lease comes to an end, we're to be signed a tenant to a 1-month lease and continue a succession of 1-month leases until the landlord is able to raise the rent. So the rent will go up, but only after the catastrophic emergency has come to an end, because the landlord doesn't have to sign the tenant to a year lease because the emergency could end 2 months later. So instead, a series of 1-month leases until the emergency is ended, and then the next time the landlord can say there's a rent increase that you'll have to pay.
We have a motion for favorable with amendments. Second. Is everyone okay? Great. All right. Sorry, go ahead, Senator West.
I intend to vote against the bill. I think we've improved the bill as much as we can under the circumstances, but I have to be recorded negatively.
Okay. Okay. All right, we'll move on. Let's go back to House Bill. Are we going to roll call it, or you want to? Okay, roll call. Can we get Senator Walsberger back? Hold on.
He's not voting, but he said that he was voting.
So he voted yes. Okay, good. So, sorry.
Senator Lee.
Yes.
Senator Castley.
No.
Senator Heddleman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
Bill passes. Favorable with amendments.
The House bill conform.
No.
Bring up the Senate bill. Conform the Senate bill to what we just did with the House bill. Record the same votes. Is that okay? All right.
What's the Senate bill number? 910. Okay.
Okay. Yes. We also need to. The JJRC, the bill that we did yesterday. We need to conform the House bill to what we did to the Senate bill.
Just one thing to.
Go ahead.
Hold on 1 second. Sorry. So here we go.
So just one thing to note, we were working off the amendments that conformed to the House yesterday, but narrowed the bill down for JJRC. One thing I did want to note was in the continuation of the council, the House amendments had altered the chairmanship for the JJRC. It wasn't specifically discussed, but the plan was going to be to continue with that unless the committee had an issue with it. So specifically, the chairmanship couldn't be held by a DJS employee or somebody contracted by DJS. That wasn't in the original bill, so just wanted to put that in front of the committee to make sure that that was what was going forward with both bills.
House bill to what we did with the Senate bill. Okay. Same. I think we voted unanimously on that, but okay.
Doesn't somebody voting against it?
No, same votes. It was unanimous.
Okay.
All right. So then, Jamie, let's do House.
It's not a cross file, but it is identical to Senate Bill 201, which provided for automatic expungements after 3 years. And must appear violations of the transportation article. Court would, or the record would be eligible for expungement or would need to be expunged if there was no charge in the case resulted in a disposition other than acquittal, dismissal, not guilty, or null pros, except null pros with requirement of drug or alcohol treatment. Yeah, we do.
House Bill 238? We don't
Passed the House.
Yeah.
But we don't have it.
As of April 10th, it passed. Oh, wait, this is still in.
So that is today.
That's
You
in
are
rules.
correct.
It hasn't been right across the desk.
Gotcha.
It wouldn't even, it has to get out of rules. Okay.
The floor starts at 12:20. We're going to take a 5-minute break. We'll come right back for a few more bills, and then we're out of here. Okay, 5-minute break. All right, we're going to come back right after the floor to conclude our voting session.